See the mommy won't stay for your meal, getting all the piece of pie for your wife. Everybody wanna know how it feels.
Last time we were discussing the objection petitions which are filed by the judgment debtor. Now there are certain occasions that objection petitions are filed by the third parties. Suppose A filed a suit for the recovery of possession. His suit for possession is decreed and he is entitled to get the possession of the property. He will file an execution petition, and in that execution petition a bailiff shall be issued. The court issuing the warrant of possession shall issue the same to the bailiff for the delivery of the property, for the recovery of the possession. Now the bailiff goes at the spot. When he reaches there, he finds that some other person is in occupation of the property. He is in occupation of the property and he states, I am owner of the property. I am sitting and occupying the same on my own account and I have nothing to do with the judgment debtor. Now the course open is that the bailiff shall report the matter to the court that someone is resisting the execution of the decree. Now when the report comes in the court, the decree holder shall move an application to the court under Order 21, Rule 97. That rule reads as follows. Where the holder of a decree for possession of immovable property or the purchaser of any such property sold in execution of decree is resisted or obstructed by any person in obtaining possession of the property, he may make an application to the court complaining of such resistance or obstruction. The court shall fix a day for investigating the matter and shall summon the party again whom the application is made to appear and answer the same. The provisions of this rule are meant to enable determination of genuine resistance by the third party. Another situation is that instead of the decree holder, the person resisting the decree appears in the court and makes an application. In both these situations, the court shall investigate into the matter and will decide whether he is bona fide in possession of the property or not. If he is in possession of the property on his own account, the application of the decree holder shall be dismissed. But if the court finds that the obstruction is on behalf of the judgment debtor or the person resisting the decree has no right to resist the same, the court shall pass an order accordingly. So the order shall be passed under Order 21, Rule 98 if the obstruction is not bona fide. Now the question is that if a person is in bona fide possession of the property, he can resist the decree. His resistance of the decree is considered to be a genuine one. But now what happens? The court is to decide the questions arising between the parties. So under Order 21, Rule 103, all questions arising as to title, right, or interest in or possession of immovable property between an applicant under Rule 97 and the opposite party, or between the applicant under Rule 100 and the opposite party, shall be adjudicated upon and determined by the court, and no separate suit shall lie for the determination of any such matters. A person not being a judgment debtor, against whom an order was made under the Rule 98, 99 and 101, could institute a suit to establish the rights that he claimed the such property in the proceedings. But this was an old rule. In the earlier days, it was that he had the right to file a suit. But now, under 3 says that no separate suit is competent. There was a time when the suit was competent, but now the latest law is that no suit is competent. A separate suit shall not lie. And all questions relating to title, relating to right, relating to interest or possession of immovable property between the applicant under Section 90 or under Rule 97, under Rule 100 shall be decided by the court who is executing the decree. So the execution of the decree is the necessity for the determination of these questions, and the execution should not be hindered on account of frivolous or resistance. Suppose A files an objection petition in the court that he is occupant of the property within his own rights. Then he shall file this application in the court which is executing the decree, and no separate suit shall lie. And when such application is filed in the court, all the rights interest are to be determined by the court, and no separate suit is competent. This is the crux of Rule 103. So this rule was enunciated in order to avoid the complications of suits. If a third person files a suit and the same proceedings continue in the same suit, then there will be no end to it. Next time someone else will come and will file a suit, then other will come and file a suit. In this way, one way or the other, the suit shall be continuously filed. So this rule has been enunciated for the purpose of curtailing the proceedings or the speedy disposal of justice. If A files a suit against B and the C is in possession of the property, then the A should suffer for that. Why did not we plead him as a party to the suit? If any third person was in possession of the property and was claiming his title, interest or legal right as to the property, it was incumbent upon the decree holder to plead him as a party to the suit when he filed the suit. But if he abstained from doing that, and later on the court comes to the conclusion that the suit was not properly instituted by the person against the person who was in actual possession of the property, then his execution shall fail. His decree shall be inexecutable. It shall not remain capable of execution. But there is a thing which is to be noted, that it does not apply to the occupant pendentility. Any person who enters into the property during the pendency of the suit is not protected. even if he has any right in the property. If he has a right in the property, he should himself come in the court and explain his right. But if he is not explaining his right and he is not contesting, he is not giving his claim in the court, then he shall not be entitled to any relief claim. So 102 rule, nothing in Rule 99 and 101 shall apply to resistance or obstruction in execution of a decree for the possession of immovable property by a person to whom the judgment debtor had transferred the property after institution of the suit in which the decree was passed or the possession was given. The provision of this rule only apply to decrees for possession of immovable property, but the principle also apply to decrees for immovable property. So this principle is called pendens during pendency of the suit. If the judgment debtor transfers his rights in favor of a person and gives him possession of the property, and after giving him the possession of the property, a decree is passed without him pleading him as party, then that decree shall also be effective against that person who was in possession of the property and got the property transferred during the pendency of the suit. So this is called that a transferee pendentility is not entitled to any protection in the law.